So years ago, when I was a college student in Virginia, some of the other students would joke that the dormitory was against the law because there was an old law on the books in Virginia saying that it was illegal for more than a dozen women to live in the same building, and the dormitories had well more than a dozen women living in them. This law was a law on the books from the 1800s, and it had been written as a way to prohibit brothels. So the law considered any house with more than 12 women living in it a brothel, and thus illegal. And of course, it was a joke because this law was completely obsolete. It was not enforced anymore, as is obvious by the fact that dormitories full of women existed. And there are laws all like this all around the United States and other countries. They're called dead letter laws, laws that have become obsolete, and they're still in the books, but they're not enforced anymore. If you went to a police officer and complained that someone was violating this law, they would just look at you funny. No court would prosecute it. For example, in Chicago, in the city of Chicago, female bartenders are illegal. But of course, there are female bartenders in bars all throughout the city. No one would ever prosecute this case. No one would get in trouble for violating this law. It's also illegal in Chicago to display any flag other than the American flag. But of course, people display other flags all the time. And so you could look at this from the point of view of someone like Roscoe Pound in sociological jurisprudence, and they would tell you that, okay, here's a great example of how law does not change. We have these laws on the books that go back to the 1800s when society was very, very different. We have laws regulating technologies that are completely obsolete, like steamboats and steam trains and horses and buggies, and they haven't been changed in the past 100, 200 years, and they're still on the books. On the other hand, you could say, no, the law has changed because these rules on paper are no longer enforced. They are not relevant at all to the modern legal system. No police officer will arrest you for these. You cannot file suits in court over these, and no judge would ever enforce these laws. They are effectively dead. And this last interpretation, that the law has actually changed, even if the written law is the same, the way the law is enforced is different. So the law is, for all practical purposes, different. That's an observation that a legal realist would make. So at the last lecture, we talked about how there were two sociological movements within the legal profession. Law professors, judges, legal scholars started recognizing this need for more sociological knowledge. One of those movements was sociological jurisprudence, which critiqued legal formalism as an ideal and argued that often cases were being decided badly because the judges were being too formalistic. Legal realism also had its bone to pick with formalism, but it was very, very different criticism. For legal realists, the problem with formalism isn't so much that this is a bad ideal. They thought it was a bad description. So legal formalists, some of them were actually in favor of more formalism. They thought the law was not formalistic enough. Their critique of formalism was as a description of our legal system. They said, our legal system is not nearly so formalistic as you might think. If you just look at the rules on paper, or the way people justify their decisions, you think this is a very rule-driven system, very logical. But if you actually look at legal cases, you see that the rules do not get you that far. So this is the main thrust of legal realism. It was a movement among legal scholars, judges, lawyers, people in law schools, that said we should look at how the law works in practice. And how the law works in practice is often different from the written rules. Dead letter laws are one extreme example of that, but you have other less extreme examples, things like how one jurisdiction might enforce a law more strictly than another jurisdiction, or interpret it a little bit more broadly, a little bit more narrowly, and things like that. So their argument was that modern law is not quite as formalistic as it's made out to be. One figure who was influential and might be considered the founder of legal realism was Oliver Wendell Holmes. He was a lawyer and law scholar who went on to become a Supreme Court justice. He wrote an influential essay called The Path of Law, in which he argued that we should approach the study of law not as the study of rules and books and their logical relationships to each other, but as the study of what law actually does. And he argued that we should do this because the written rules by themselves aren't enough to predict the outcomes of legal cases. If I told you what the facts of the case were and I told you what the rules were, you could guess the outcome of the case, but you wouldn't be right all the time. In fact, you might be wrong pretty often. Because even when two cases seem to have very similar facts, two people both accused of theft, both have a witness who saw them steal something, the legal statutes say, theft brings this penalty, they might wind up getting very different penalties or very different outcomes. One's convicted, one's acquitted, one gets a slap on the wrist, another gets a severe penalty, and so forth. In fact, he said the main function of rules in our system isn't as something that determines the case, it's something used to justify the case. And so, lawyers and judges are very, very good at logical reasoning and argument, but they often kind of work backwards. They have some moral or personal hunch about how the case should be decided, and then they go searching for the proper rules they can use to justify their decision. And I want to make this decision, what rules do I need to do, and put this rule and that rule and this rule, and they add up to my decision. So his approach to the study of law was to define law as behavior. He said when he talked about law, he meant nothing more than what the courts will do in fact. It's not the study of rules in books, it's the study of the actual behavior of the courts. And so if there's a dead-letter law that no court in the land will ever enforce, that's not really a law. It's only a law if the courts enforce it. So Holmes was writing back around the turn of the 20th century, around the same time that Roscoe Pound was active. And so you have this movement gaining some ground among legal scholars in the early and mid-20th century, around the same time as sociological jurisprudence. And of course, any movement that influences many people will have many different interpretations, but one influential legal realist was Carl Llewellyn, and he tried to sum up what was common among all the people who called themselves legal realists or otherwise identified with this way of thinking. So he came up with these tenets of legal realism. One of these tenets was that legal realists should focus on cases. So we're not looking here at the legal system as a whole, or the statutes that are on the books, or the way legislation is passed. We're looking at individual cases handled by courts or by the legal system otherwise, and looking at what sort of variation there is in the outcome of those cases. Legal realists also should recognize that written rules aren't usually enough to explain the outcome, which is not to say that the rules have no influence at all. If speeding is illegal in this state and the next state and the state after that whatever state you're driving in, you take a risk of getting a ticket if you speed. It's just that depending what town you're in or what state or what city, that risk is going to be variable. And in some cities, maybe the police have an informal rule. They don't bother to pull you unless you're doing at least 10 over the speed limit. And others, if you're doing 2 or 3 over, they might pull you because they have a stricter enforcement. And sometimes maybe they'll let you go if you have your kids in the car because, who wants to give a ticket to somebody in front of their kids? And 10 million other factors that might explain why one person gets a ticket and another doesn't, other than the written rules. Legal realists also recognize that law is always changing, even if the written rules aren't. Even if those dead-letter laws are still on the books, the fact that they're not being enforced now means law has changed, and that kind of thing is happening all the time. So this has some implications. If judges have a lot of leeway in how they interpret a case, if often they're going with their hunch and kind of working backwards to figure out which of the many laws justifies their hunch, if they can interpret things in a broader way or a narrower way, or enforce the law more strictly or less strictly, then we have to face the fact that judges don't just enforce a law that's been written by somebody else. They are effectively making the law. Now this cuts to the heart of Caesar Beccaria's reform, where he said there should be a distinction between lawmaking and applying the law in judging cases. Legal realists say that distinction's fuzzy, because the judges, whenever they decide to interpret things in a different way, they're effectively changing the law. And legal realists also wanted research. They wanted to measure the gap between law on the books and law in reality. This is something, of course, that would vary across time and place and from one case to another, and they wanted research to measure how law actually behaves and just how different law is in reality from what it says it's supposed to be on the books. Legal realism could raise some uncomfortable implications for liberal jurisprudence. Liberal jurisprudence is widely shared as the ideology of modern law and the ideology, the philosophy of what law ought to be. And legal realism calls into question some of it. For example, we have this belief that there should be elected lawmakers. Our laws come from people in Congress or Parliament or whatever you have in your country that are elected to make laws, and these people are supposed to be representatives of the common people, of the citizens, and thus we argue that our laws derive from the consent of the governed, because we choose and elect our lawmakers and can vote them out of office if they don't make the laws we want. The theory is that our laws are ultimately partly our choice. This causes this whole idea into question, because if judges make the law, if judges can change the law just by interpreting laws differently or ceasing to enforce a rule they don't like, and judges aren't elected, are our laws really the result of elections? Are they really deriving from consent of the governed? This also calls into question the legitimacy of judicial review. In America, we have this three-pronged structure to our government: the judicial branch, the executive branch, and the legislative branch. And the idea is supposed to be a system of checks and balances between the three, so power doesn't get concentrated into any one branch. And the judicial branch is supposed to review the laws and make sure that they're constitutional. That is, that new laws created by Congress are consistent with the most fundamental law of the land, the U.S. Constitution. Well, if judges have so much leeway in deciding cases, if they can argue one way or another and justify different outcomes, then is judicial review really just the judges making the law? Or to put it another way, does the Supreme Court reject a law because it's unconstitutional? Or does the Supreme Court change the Constitution? If they have a lot of leeway in making their decisions, if there's many different ways to justify many different outcomes, then it's less a matter of the court votes against something because it's unconstitutional than a matter of the court makes something unconstitutional. And you can see this in the history of Supreme Court decisions where, one court in one decade will decide that a law is constitutional. Yes, it's completely consistent with our fundamental law of the land. And then another Supreme Court, a decade later, or 2 decades later, will make the opposite decision and decide, no, in fact, that is not unconstitutional. It doesn't fit with the law of our land. It starts to seem like it's less like we're being ruled by the Constitution and more like we're being ruled by Supreme Court justices. Finally, legal realism questions the entire possibility of a high level of formalism and universalism. Remember, these are two of the three main pillars of liberal jurisprudence, that we have these abstract rules governing our system, that the rules are applied equally to everybody regardless of what's going on. This is what we call rule by law. We have rule by law and not by just the whims of the powerful. Well, if the rules aren't enough to explain case outcomes, do we really have rule by law, or do we have rule by judges? And you can carry these implications as far as you want. Some people have taken them to make very radical arguments. One legal realist named Fred Rodell criticized the entire legal profession as what he called a high-class racket. He wrote this book, Woe Unto You Lawyers, condemning the practice of law in modern America. But his whole idea was that law is just smoke and mirrors. It's all shadows. Written law is, first of all, Caesar Beccaria said written law should be clear and understandable by the average person. It's not. Nothing about the modern law is clear and easily comprehensible. It's full of Greek and Latin phrases and Old English words and things used in very technical senses that your common person doesn't use the word that way. So it's very difficult for the average person to understand. And he says this is what gives lawyers their power and status in society. The average person's mystified by the law. They don't understand it, and they completely depend on lawyers to translate these things for them. And he made another argument. He said that the law is so vague that it's often meaningless. It's full of these weasel words, like there's no simple statute like, okay, if you spit on this platform, you're going to be fined $50. Usually it's got some sort of words in there like, if you maliciously and willfully spit on this platform, then you'll be fined $50. And that maliciously and willfully, that's a wiggle word. You can argue about whether it was malicious or not, whether it was willful or not, and there's no hard and fast standard for deciding what it is. And these things allow for all the room of interpretation and law. And then, there's an argument that it should be there. We want our law to have some room for interpretation so it fits cases correctly so that people can use their wisdom to make good legal decisions. But for Rodell, this makes law such an unpredictable thing that, you can justify any decision you want. So people say law should be mechanistic. He says, yeah, it is like a mechanism, but it's more like a vending machine where if you know what product you want out of the vending machine, you know which button to press to get it. And if you're a lawyer or judge and you want to have a certain decision, you know which legal principle you reach for and say, okay, this is the important principle here, and then you deductively reason from that to the conclusion you wanted to make anyway. So for Rodell, legal expertise is mostly a matter of word games, of cooking up justifications and playing with logic to try to get to the outcome you want. But it's a very expensive word game for those of us who have to hire the lawyers. Legal realism, like sociological jurisprudence, had a need for empirical social research. And in fact, it spawned a lot of research, because the main tenet of legal realism was that we can't understand law just by studying the law codes, by studying law on the books. We need to actually study how individual cases are handled, and how even in the same time and place, different cases might have different outcomes, even if they're about basically the same things. And so legal realism raises the question of, if laws alone don't explain case outcomes, what does? Opening the door for us to look at the social factors like the status of the parties involved, or their relationships with each other, that do help explain these outcomes.